Though plaintiffs boldly probe the outskirts of law, the only enterprise they resemble is RICO. The federal agency 11 decks up is familiar with their prime directive and will gladly refit them for their next voyage.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
All right, this next story is about copyright trolls getting their butts handed to them. Now, this is a couple years old, but I realized that we never covered it on the channel with the energy and effort that it deserves. So I present to you Judge Otis Wright's Star Trek opinion in Prenda Law's Ingenuity 13 matter. Now, Prenda Law was the copyright troll that basically everybody thinks of and calls me about when they think they're getting copyright trolled. Prenda Law made their own copyrights, forged signatures, and other improper things, including getting a plaintiff or getting a defendant to flip on other defendants in a case when there wasn't any conspiracy between the defendants, and then telling the judge that there was a conspiracy so they could get thousands of IP addresses or thousands of subscribers' identities to then further their copyright trolling scheme. Well, the principals, John Steele and Paul Hansemeyer, who were behind Prenda Law's copyright trolling scheme, are now in federal jail, in a federal penitentiary, for their fraudulent scheme. This was the opinion that undid their scheme. This is in the United States District Court of California, Central District of California. This is an order issuing sanctions, and this is Judge Otis Wright. And he writes in the theme of Star Trek. This is the Star Trek opinion. And he starts, "The needs of the many outweigh the needs of the few," said by Spock from Star Trek II, The Wrath of Khan from 1982. Plaintiffs have outmaneuvered the legal system. They've discovered the nexus of antiquated copyright laws, paralyzing social stigma and unaffordable defense costs. And they exploit this anomaly by accusing individuals of illegally downloading a single video. They then offer to settle for a sum calculated to be just below the cost of a bare bones defense. For these individuals, resistance is futile. Most reluctantly pay rather than have their names associated with illegally downloading. So now, copyright laws originally designed to compensate starving artists allow starving attorneys in this electronic media era to plunder the citizenry. Plaintiffs do have a right to assert their intellectual property rights so long as they do it right. But plaintiffs' filing of cases using the same boilerplate complaint against dozens of defendants raised the court's alert. It was when the court realized plaintiffs engaged their cloak of shell companies and fraud that the court went to battle stations. Right? The court issued its February 7th, 2013 order to show cause regarding sanctions to allow counsel Brett Gibbs to explain why he ignored the court's discovery stay order, filed complaints without reasonable investigation, and defrauded the court by asserting a copyright assignment secured with a stolen identity. They had their gardener, Alan Cooper, sign here, and then there was a paper underneath, and he really signed the paper underneath. As evidence materialized, it turned out that Gibbs was just a red shirt. Gibbs' behavior in the trolling collective was controlled by several attorneys under whom other individuals took their orders. Because it was conceivable that these attorneys and others were culpable for Gibbs' conduct, the following parties were ordered to appear: John Steele of Prenda Law, Paul Hansemeyer, same, Paul Duffy, Prenda Law, rest in peace, Paul Duffy. He died because of this scheme. Paul Hansemeyer and John Steele took advantage of his alcoholism and caused him to stay stuck in the illness, the disease, the sickness that is alcoholism, so that they could continue to take advantage of him. He is a victim here too. Angela Van de Hemel of Prenda Law, Mark Lutz of Prenda Law, Alan Cooper, that's the guy whose identity was stolen, Peter Hansmeier, who's Paul Hansmeier's brother and was doing the forensics, Prenda Law itself, Livewire, Steel Hansmeier, AF Holdings, Ingenuity 13, the forensics company, Alan Cooper, etc. These parties were ordered to show cause why they should not be sanctioned for their behind-the-scenes role in the conduct facially perpetrated by Gibbs. These parties were also ordered to explain the nature of their operations, relationships, and financial interests. The court has a duty to supervise the conduct of attorneys appearing before it. The power to punish contempt or to coerce compliance with issued orders is based on statutes and the court's inherent authority. Though this power must be exercised with restraint, the court has wide latitude in fashioning appropriate sanctions to fit the conduct. Under the court's inherent authority, parties and their lawyers may be sanctioned for improper conduct. This inherent power extends to a full range of litigation abuses. The litigant must have engaged in bad faith or willful disobedience of a court's order. Sanctions under the court's inherent authority are particularly appropriate for fraud perpetrated on the court. Based on the evidence presented, on the papers and through sworn testimony, the court finds the following facts, including those based on adverse inferences drawn from Steele, Hansmeier, Duffy, and Venden Hemmel's blanket refusal to testify. They all refuse to testify based on the Fifth Amendment, and the Fifth Amendment does have a privilege against self-incrimination, but the court may still draw an adverse inference against them in a civil proceeding. This is extremely important. You cannot take the Fifth Amendment in a civil proceeding without consequences. Steele, Hansmeier, and Duffy are attorneys with shattered law practices. Seeking easy money, they conspired to operate this enterprise and formed the AF Holdings and Ingenuity 13 entities, among others, for the sole purpose of litigating copyright infringement lawsuits. They created these entities to shield the principals from potential liability and to give an appearance of legitimacy. AF Holdings and Ingenuity 13 have no assets other than several copyrights to adult entertainment films. There are no official owners or officers for these two offshore entities, but the principals are the de facto owners and officers. The principals, Duffy, Hansmeier, and Steele. The principals started their copyright enforcement crusade about 2010 through Prenda Law, and I was getting my law license at the end of 2011, so I was coming up and I was ready for them, and I took them on, which was owned and controlled by them. Their litigation strategy consisted of monitoring BitTorrent download activity of their copyright movies, recording IP addresses of the computers downloading the movies, filing suit in federal court to subpoena internet service providers for the identity of the subscribers to these IP addresses, and sending cease and desist letters to subscribers, offering to settle each copyright claim for about $4,000. This nationwide strategy was highly successful because of statutory copyright damages, the subject matter, and the high cost of litigation. Most defendants settled with the principals, resulting in proceeds of millions of dollars due to the numerosity of defendants. These settlement funds resided in the principal's accounts and not in accounts belonging to the entities. No taxes have been paid on this income. For defendants that refused to settle, the principals engaged in vexatious litigation designed to coerce settlement. These lawsuits were filed using boilerplate complaints based on a modicum of evidence, calculated to maximize settlement profits by minimizing costs and effort. The principals have shown little desire to proceed in these lawsuits when faced with a determined defendant. Instead of litigating, they dismiss the case. When pressed for discovery, the principals offer only disinformation, even to the court. The principals have hired willing attorneys like Gibbs to prosecute these cases. Though Gibbs is culpable for his own conduct before the court, the principals directed his actions. In some instances, Gibbs operated within narrow parameters given to him by the principals, whom he called senior attorneys. The principals maintained full control over the entire copyright litigation operation. The principals dictated the strategy to employ in each case, ordered their hired lawyers and witnesses to provide disinformation about the cases and the nature of their operation, and possessed all financial interests in the outcome of each case. I can confirm that I spoke to John Steele on the phone and asked him for a copy of a court filing in one of the cases. They had intentionally filed a subpoena in Illinois, Cook County District Court, and my client was in Pennsylvania. So I couldn't get a copy of the subpoena that was sent to my client readily. So I called them and asked, could I have a copy of the subpoena? This is normally a completely normal thing to get a copy of a document that's been served on your client. If I can't get it from the client for some reason, yeah, I'll be happy to call the opposing counsel. They can email it right over. No, I was told to go F myself, and then he hung up on me. The principals stole the identity of Alan Cooper. The principals fraudulently signed the copyright assignment for popular demand using Alan Cooper's signature without his authorization, holding him out to be an officer of AF Holdings. Alan Cooper is not an officer of AF Holdings and has no affiliation with plaintiffs other than his employment as a groundskeeper for John Steele. There is no other person named Alan Cooper related to AF Holdings or Ingenuity 13. The principals ordered Gibbs to commit the following acts before this court: file copyright infringement complaints based on a single snapshot of internet activity, name individuals as defendants based on a statistical guess, and assert a copyright assignment with a fraudulent signature. The principals also instructed Gibbs to prosecute these lawsuits only if they remained profitable and to dismiss them otherwise. Plaintiffs have demonstrated their willingness to deceive not just this court, but other courts where they have appeared. Plaintiffs' representations about their operations, relationships, and financial interests have varied from feigned ignorance to misstatements to outright lies. But this deception was calculated so that the court would grant plaintiffs early discovery requests, thereby allowing plaintiffs to identify defendants and exact settlement proceeds from them. With these granted requests, plaintiffs borrow the authority of the court to pressure settlement. Although the court originally notified the parties that sanctions would be imposed under Rule 11 and Local Rule 83, the court finds it more appropriate to sanction the parties under its inherent authority. The bankruptcy court's failure to specify in advance of the disciplinary proceedings in a previous case that its inherent power was a basis for those proceedings did not serve to undercut its sanctioning authority. So the court doesn't need to say that, and then they said they don't need to say that. Okay. The sanctions for plaintiffs' misconduct are as follows. The court maintains that its prior analysis of plaintiffs' Rule 11 violations is accurate. Plaintiffs can only show that someone using an IP address belonging to the subscriber was seen online in a torrent swarm. But plaintiffs did not conduct a sufficient investigation to determine whether that person actually downloaded enough data or even anything at all to produce a viewable video. Further, plaintiffs cannot conclude whether that person spoofed the IP address, is the subscriber of that IP address, or is someone else using that subscriber's internet access. Without better technology, prosecuting illegal BitTorrent activity requires substantial effort in order to make a case. It is simply not economically viable to properly prosecute the illegal download of a single copyrighted video. Enter plaintiffs and their cottage industry lawsuits. Even so, the court is not as troubled by their lack of reasonable investigation as by their cover-up. Gibbs argued that a deep inquiry was performed prior to filing. Yet these arguments are not credible and do not support Gibbs' conclusions. Indeed, Gibbs' arguments suggest a hasty after-the-fact investigation and a shoddy one at that. For instance, Gibbs characterized Marvin Denton's property as a very large estate consisting of a gate for entry and multiple separate houses structures on the property. He stated this to demonstrate the improbability that Denton's Wi-Fi signal could be received by someone outside the residence. But Denton's property is not a large estate. It is a small house, closely packed residential neighborhood. There are no gates visible. Gibbs' statement is a blatant lie. His statement resembles other statements given by plaintiff in this case and other cases, statements that sound reasonable but lack truth. Thus, the court concludes that Gibbs, even in the face of sanctions, continued to make factual misrepresentations to the court. Nevertheless, Rule 11 sanctions are inappropriate here because it is the wrong sanctions vehicle at this stage of litigation. The cases have already been dismissed and monetary sanctions are not available. The more appropriate sanction for these Rule 11 violations is what the court has already imposed: denial of the requests for early discovery. But in addition to Gibbs' misrepresentations, there is the matter of the ignored court order vacating early discovery. The evidence does not show that the order was ignored because of a miscommunication. The order was purposefully ignored, hoping that the ISPs were unaware of the vacatur and would turn over the requested subscriber information. And then there's the Alan Cooper forgery. Although a recipient of a copyright assignment need not sign the document, a forgery is still a forgery, and trying to pass that forged document off to the court smacks of fraud. Unfortunately, other than these specific instances of fraud, the court cannot make more detailed findings. Nevertheless, it is clear that the principal's enterprise relies on deception. Part of that ploy requires cooperation from the courts, which could only be achieved through deception. In other words, if the principals assigned the copyright to themselves, brought suit in their own names, and disclosed that they had the sole financial interest in the suit, a court would scrutinize their conduct from the outset. But by being less than forthcoming, they defrauded the court. They anticipated the court would blindly approve their early discovery requests, thereby opening the door to more settlement proceeds. The principals also obfuscated other facts, especially those concerning their operations, relationships, and financial interests. The principal's web of disinformation is so vast that the principals cannot keep track themselves. Their explanations of their operations, relationships, and financial interests constantly vary. This makes it difficult for the court to make a concrete determination. Still, the court adopts as its finding the following chart detailing the plaintiff's relationship. Though incomplete, this chart is about as accurate as possible given plaintiff's obfuscation. Let's take a look at the chart. So that's what they look like. That's John Steele in the upper left. That's Paul Hansmeier. Paul Duffy really did look like that, and you can kind of see he's red and a little puffy in the face because of his alcoholism. Salt Marsh was the name of one of their offshore holding companies. Peter Hansmeier, Paul Hansmeier's forensic brother. And then there's Brett Gibbs. There's the computer forensics section, and in the middle bottom here are all of the different clients. And then they created these four: Guava, Art Oaxaca, Ingenuity 13, AF Holdings. We're all part of it. As for Venden, Hemmel, Lutz, and Hansmeier, they are not without fault, even though they acted under orders from the principals. They were not merely assimilated. They knowingly participated in this scheme, reaping the benefits when the going was good. Even so, their status as non-attorneys and non-parties severely limits the sanctions that could be levied against them. Despite these findings, the court deems these findings insufficient to support a large monetary sanction, a 7-digit sanction adequate to deter plaintiffs from continuing their profitable enterprise. Even if the court entered such a sanction, it is certain that plaintiffs will transfer out their settlement proceeds and plead paupacy. Yet, plaintiffs' bad faith conduct supports other, more fitting sanctions. First, an award of attorney's fees to defendants is appropriate. This award compensates them for expenses incurred in this vexatious lawsuit, especially for their efforts in countering and revealing the fraud perpetrated by plaintiffs. So far, only Morgan Peets and Nicholas Rinaldo have appeared. Those are the good guys on the defendant's side. Upon review, the court finds that Peets' expenditure of 120.5 hours at an hourly rate of $300 reasonable based on his experience, work quality, and quantity. I think it's $36,000. And quantity of necessary papers filed with the court. Although many of these hours were spent after the case was dismissed, these hours were spent in connection with the sanction hearings, time well spent. Similarly, the attorney's fees and costs incurred by Rinaldo also appear reasonable. Therefore, the court awards attorney's fees and costs in the sum of $40,659 to Doe, $36,150 to Peets, $1,950 to Rinaldo, $2,226 for Peets' costs, and $333 for Rinaldo's costs. As a punitive measure, the court doubles this award, yielding $81,319.72. This punitive multiplier is justified by plaintiffs' brazen misconduct and relentless fraud. The principals, AF Holdings, Ingenuity 13, Prenda Law, and Gibbs are liable for this sum jointly and severally, and shall pay this sum within 14 days of this order. Joint and several liability means that each one of them is responsible for the entire sum until the entire sum is fully paid. So it doesn't mean that they each have to pay the sum. It means that until the sum is entirely paid, they are all entirely responsible for it and can be held. You can get a judgment against each of them for the 81,000. And then if just one of them pays it, well, then it's between them and they can go figure out, so they have to figure out how they're going to pay it between them in 14 days. Otherwise, things get complicated. Second, there is little doubt that Steele, Hansmeier, Duffy, Gibbs suffer from a form of moral turpitude unbecoming an officer of the court. To this end, the court will refer them to their respective state and federal bars. And we know what happened there. John Steele and Paul Hansmeier are literally behind bars now. Third, though plaintiffs boldly probe the outskirts of law, the only enterprise they resemble is RICO. The federal agency 11 decks up is familiar with their prime directive and will gladly refit them for their next voyage. The court will refer this matter to the United States Attorney for the Central District of California. The court will also refer this matter to the Criminal Investigation Division of the Internal Revenue Service and will notify all judges before whom these attorneys have pending cases. For the sake of completeness, the court requests Pete's to assist by filing a report within 14 days containing contact information for 1. Every bar where these attorneys are admitted to practice, state and federal, and 2. Every judge before whom these attorneys have pending cases. For the same reason stated above, the court will refer Duffy and Gibbs to the Standing Committee on Discipline for this district under local rules. And the court then concludes, Steele, Hansmeier, Duffy, Gibbs, Prenda Law, AF Holdings, and Ingenuity 13 shall pay, within 14 days of this order, attorneys' fees and costs totaling $81,319.72 to Doe defendant. The court enters additional non-monetary sanctions in accordance with the discussion above. It is so ordered. May 6, 2013, Judge Otis D. Wright II, United States District Judge. So that was the opinion and the work that started the downhill rolling of the snowball that eventually wrapped up the whole Prenda Law copyright trolling scheme. So what did you think of that? I thought it was particularly entertaining, and I hope that you enjoyed it too. So beam yourself down to the comments and let us know what you think there. Make it so. So that's our show. Thank you for joining me. I am Leonard French, your favorite copyright attorney. Remember, this is a community-supported legal education and legal news and stories channel. So you can help us by liking the video, by subscribing and clicking the bell if you want to, and by supporting us on patreon.com/ljfrench and sponsors.com/law. Those are our financial support platforms. If you would like to subscribe, you can subscribe on Twitch to our live shows on Sunday, and then usually there's one on Wednesday or Thursday that we produce these videos. And you can, of course, subscribe to us on YouTube. We also sell merch through a Teespring store that we will be expanding very shortly once I get to my final destination. So thank you very much for joining me. I am Leonard French, your favorite copyright attorney. I will see you in the videos that drop. I love you all. Bye.